Let's bring in Adam Goldenberg now, lead counsel for You Are Pride. Adam, thanks a lot for giving me your time today.
Thanks for having me.
I want to get your reaction to the judge's ruling. This is something that you were hoping for. This, of course, coming with the filing of the injunction last month.
Well, we're very grateful that the court agreed with us and granted the injunction. We obviously believe that it was the right decision. And importantly, in making that decision, the court found, as you mentioned earlier, that irreparable harm would be suffered by gender diverse youth, who the Supreme Court of Canada has recognized are among the most vulnerable members of our society. Irreparable harm would be suffered if this policy were not enjoined at this stage while we have the litigation ongoing about its constitutionality. So we're grateful for that ruling. It's the right decision. The policy should not go into force while we are debating its constitutionality.
Looking at the response, though, from the government, from Premier Scott Moe, he's looking to recall legislature after Thanksgiving, looking to pass legislation to protect parents' rights. If this does happen, what's the recourse?
Well, first of all, it's a horrifying decision for the government to say that despite a court having found that irreparable harm would be suffered by some of the most vulnerable minority youth in our school system, in any school system, that the government is prepared to use the extraordinary measure of the notwithstanding clause to inflict that harm deliberately, intentionally on students by way of legislation. The fact that this clause has only been invoked 3 times in the history of Saskatchewan, or rather the history of the Charter, and now it's being used to discriminate against gender diverse youth is just a terrible, terrible precedent and something that should cause deep concern to anyone who is a member of any minority group or anyone who cares about our rights under the Charter. And what's really remarkable is that the case isn't over yet. The government has the opportunity. We have a hearing scheduled in November. They can make their case, and I expect they've got excellent lawyers. They'll make a strong case for why they say this policy is constitutional. But they aren't going to do that, apparently. Apparently, they think they can just pick up their marbles, go home, and use legislation to enact this policy that, again, a court has now found will inflict irreparable harm on children. And I think that's something the government is going to have to answer to, not just to voters, but to its own conscience, quite frankly. It's unconscionable.
Kids are the ones that are all stuck in the middle of all of this. Some who might be in the middle of trying to understand, who they are and where they want to be in society. There's a huge gray area here around a child's rights. And by gray area, I mean, at what point can it be determined when a child can make their own decision without influence? That I know, of course, we're trying to protect. We're trying to protect their rights. But can you walk us through that as we sort of walk the line here to understand the both sides of the issue?
Sure, it's not such a gray area. The law is quite clear that where a child's interests begin, the right of parents to control the child and the best interests of the child are paramount in any number of areas of Canadian law. And the decision that came out today is consistent with that. Look, everyone agrees, and you'll see this in today's decision too. All of the experts whose evidence the court reviewed in concluding, as it did today, that irreparable harm would result from this policy, everyone agrees that it is best for children to have parental involvement at every stage of their upbringing. It is best for gender diverse kids to have their parents involved as they figure out, as you say, who they are. But ultimately, the decision of when and how to come out to one's parents is a deeply personal decision of intense importance to any LGBTQ2S plus person, and especially to gender diverse youth who are still figuring this out. And the idea that a student in that circumstance, a student who just needs a trusted adult who isn't their parents to talk about who they are, to help figure out how to navigate the difficulty of growing up, would be denied the acceptance, respect, and recognition that every other student gets in their school system because they are gender diverse. That's what's discriminatory and harmful about this policy. And so what the government really ought to do here, it's not complicated. There is a way, there have to be ways to involve parents in their students' upbringing, in their children's upbringing, where it's safe to do so, to ensure that parents do have a voice, because of course, where they safely can, they should, while at the same time allowing young people the autonomy, the dignity, the privacy to be who they are, to grow up how they are, and to come out on their own terms when they're ready to do so, to whom they choose to do so. And the fact that the government, in the face of what seems to be an obvious opportunity to sit down, to press pause, to talk to experts, to talk to students and parents and teachers and school officials, And get this right, the fact that they are instead proposing to pass legislation that will, according to the court, on the basis of evidence, inflict irreparable harm on children, that's what's so disappointing. But look at the case continues. We still have our hearing scheduled in November.
Right.
The litigation over the constitutionality of this policy will carry on until such time as it ends, and it isn't over yet.
What about protection as well of child's mental health? As I mentioned earlier, kids are the ones that are going to be stuck in the middle of all of this. And we saw with the protests that happened last week with both sides back and forth, kids literally stuck in the middle there. What about protection of their mental health?
So there was evidence about this that the court considered in making today's decision. The expert evidence is clear, we say, that outing a student to their parents, telling a child that they have a choice between coming out not on their timing, but on the government's timing, or being misgendered or dead named, being referred to by pronouns that don't accord with their gender identity, that is harmful, that invalidates their identity and can cause both short and long-term mental health impacts. Ultimately, if what we all care about here, and I think everyone who was protesting on both sides last week cares about this, the well-being of kids, surely we have to pay very close attention to the medical evidence, the expert evidence that says policies like this will harm children, will cause serious mental health problems for kids who are already vulnerable and don't need that in their lives. And frankly, for the gender diverse youth of Canada, the fact that they have become this political and legal football is disgraceful. We're talking about a tiny minority of young people who have a tough time growing up gender diverse as it is. They do not need for 1 minute to be the center of a political or partisan fight. They don't need lawyers in court fighting about whether governments should have the obligation to respect their dignity and autonomy. I would like nothing more as a lawyer than not to have to litigate cases like this. But as long as there are governments like the government of Saskatchewan that take it upon themselves to discriminate against and harm gender diverse youth because they are gender diverse, then we will have to have these fights. But the answer is so simple. We need to all agree that there's a ton of common ground here, that of course it's best for kids when their parents can safely be involved in every aspect of their lives. But kids also are individuals who have privacy and autonomy rights. Those are protected by our laws, including by the Charter of Rights and Freedoms, and they should be respected, not abrogated by the use of the notwithstanding clause.
Adam, before I let you go, as you mentioned there, the case continues. November is the date you're looking forward to. But in the meantime, as we now just a couple of weeks or so away from Thanksgiving to see where the government's going to go on this, what are you preparing for?
So we have a deadline at the end of next week to file all the remaining evidence on the underlying dispute about the constitutionality of the policy. We will meet that deadline. We expect the government to do the same, and then we'll have some days in court to cross-examine each other's witnesses if we get leave to do so later in October, and then we'll prepare to argue the case in November. The government can talk all it wants about invoking the notwithstanding clause. As long as this policy remains on the books, then our challenge to its constitutionality will continue. And frankly, even if they were to rescind it, there would then be a fight about whether the litigation should carry on anyway. But we're not going to cross that bridge until we get to it. Right now, we're focused on ensuring the court has a full and complete evidentiary record on the basis of which we intend to argue in November that this policy is unconstitutional.
Adam, we'll be watching things very closely. Good to have you. Thank you for this. Adam Goldenberg is lead counsel for You Are Pride.